Thank you. Scott Cockroft.
Here.
Keith Harvey.
Here.
Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts.
Here.
You have a quorum, Madam Chair.
Okay. The next item on
I wanted to ask you, Madam Chair, I believe last June, was it, Beth? It was June whenever you did elect officers. If you want, you can vote to keep those officers, or we can have a regular vote if you prefer.
I like it.
If you'd like, we can take a vote to keep the same officers you voted in June, so, because we were only meeting every 3 months at that particular time. Now we're meeting every other month. Or we can go with the vote.
Make a motion to retain the officers that's in place.
Second.
Okay, we have a motion by Mr. Harvey and a second by Mr. Cockcroft to keep the officers as present. All in favor, voice by saying aye.
Aye.
All opposed? The motion passes. The next is the adoption of Robert's Rules of Order. Do we have a motion on that?
Madam Chairman, I make a motion we adopt as our operating procedures Robert's Rules of Order, the latest edition.
Okay.
Second.
Okay, we have a motion by Mr. McKenzie, a second by Mr. Roberts, and a second by Mr. Harvey to adopt the current issue of the Robert's Rules of Order. All in favor, voice by saying aye.
Aye.
All opposed? That motion carries. Okay. Have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
I'd make a motion to adopt the agenda as presented.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to adopt the agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Okay. Have y'all had an opportunity to review the minutes from our December the 10th, 2015 board meeting? And if so, a motion to approve.
Madam Chairman, I make the motion that we approve the minutes as they were previously transmitted to us.
Second.
We have a motion by Mr. Roberts, a second by Mr. Harvey to approve the minutes as presented from the December 10th, 2015 board meeting. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Next, I think we're a little bit ahead of schedule, so.
Budget. We've already discussed it, but the assistant committee.
Do you want to move on down to the, like the E or F category, or you get your reports out of the way until they come? Okay. So we're going to look at the reports.
Yes, let's go ahead and take, let's skip right on to B, which is the December and January distillery report. For the alarm board for December, it was incurred a fees of $4,800 for civil penalties. All three of these were failure to turn in applications or termination notices. And you can see that just here. We had $3,100. There's 1, 2, 3, 4, 5, 6. That one. There again, it's for the same thing except for the joint venture. So, questions on that? If not, we'll move on to the next one, which you already got all this information. You get it every month. I'll take it if you had any questions, we would know about that. Okay, we can move on now to Exhibit C. Those are our monthly reports. As if you will notice, Karen Jones and McKenzie Roberts, these are two of our board members who have already expired. They serve until the governor has appointed someone else, if you so choose. because you've been coming to the board meetings, which we do appreciate. That was for December. Let me get my paper here. And then, of course, was that December?
Yes.
Yeah.
This one, I think.
Awkward how we got that. Okay, and then January, of course, it's the same thing with our members. But on the new one for January, if you would look down under, there is some legislation there. It's 1534/House Bill 1584. It does extend the Alarm Systems Contractors Board to June 30th, 2020, and will establish minimum attendance requirement for board members. I believe we do have something. It is moving. Your bill is moving to do that. Let me go ahead and give these to you now that we're talking about it. It just shows how the bill is moving. By the time we got it ready till then it's pardon for the interruption there. Legislative update. All right. Now we do have Exhibit E. The Exhibit E is a qualifying agent application review. I believe is here today. So we want to review his application, and should you have any questions, he would be here to answer. Ms. Moore, would you please come up? In case they do have any questions, but please give them a few minutes to review if they have not seen this information. While you're looking that over, I will bring to your attention that this gentleman was presented to the board on June the 7th of 1996. It had the same criminal activity record. Was approved at that board meeting. As a registered employee. You know, once they're registered employees and they come back in as qualifying agents, we do bring them back to the board.
you've not had any arrests or convictions since this incident back in the 80s? Okay.
You have included in the back, if you've got that far, a copy of the administrative report for the, and then
Trudy did
that was
that.
Trudy.
Yes.
I know you've been asked to come in today. Appreciate your time in doing so. From my part, I don't have a lot of questions. I mean, this looks pretty straightforward to me. Unless the board has an objection to it or has other questions they'd like to ask, I'd like to go ahead and make a motion to, in light of the criminal charges being as old as they are and nothing in your history since, to go ahead and make a motion to approve you for a qualifying agent license.
We have a motion by Mr. Harvey to grant Mr. Moore his qualifying agents,
A second.
and a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations, and thank you for coming in.
Good luck.
Okay, Ms. Vest?
Okay, we're going to have to jump around a little bit, looks like today too. A little bit more. I didn't want our attorney to start her report and have to stop on that. What about the education report?
There's a lot.
There's a lot on that, so
Well, can we just start on the employee applications?
we
That should-
can. Those are all criminal records, and it's going to be a while. But we can
Why
start.
don't we go ahead and do the education report?
That way we can stop and it won't really affect anything, I don't think.
Fine with
I
me.
don't think, yeah, I wouldn't
Did
think
y'all
the
have any
education-
questions about the multitude of courses we sent out? Thank you.
So we're gonna go to the G, do we have a G file?
Probably not. Those
Yeah,
are
we
the
do,
ones-
there's a
okay.
G exhibit.
Those are ones that were sent out.
Just tell us where to go.
Okay.
Let's go to G.
The first course that was sent out for review was the at-home prep, a division of Stotzenberger College in Knoxville. It's called Access Control for Residential and Commercial Applications. They asked for 16 hours of continuing ed. It's Exhibit G. This is a little bit different. This is the first time I've ever heard from this university, but they put a pretty comprehensive course together. And they didn't ask for it to be qualifying, they only asked for continuing ed. I think they're planning on increasing what they offer and come back and add some more. It's pretty well organized,
Yeah, I had a problem with that.
okay?
The course comprises, as I recall, about 4 sections, 3 of which were in good shape. but there was one section that was entitled the 2014 NEC updates for alarms, which was just really way beyond anything that alarm people should be involved with. For example, there are a number of things. There's a section on sealing and drainage, the wiring methods, receptacles, cords, switchboards and panel boards, grounding for bonding conductors. It looked like a great course for the National Electric Code, but really would have very limited application for alarm contractors. High voltage stuff, spacing from major switchboards, looked like a pretty decent NEC course, but not really applicable to the alarm industry as I would visualize it.
Not even for continuing education.
It's just way beyond what alarm people really would be involved with. It would, for any alarm people that I could envision, that course would largely be a waste of time, 90% of it. Now, the other courses that they presented were reasonable in their request. Let me refer to my notes here on this. They had one that was, that's the abstract, excuse me. They had a section on false alarm prevention, very appropriate, no problem with that. They were requesting 2 hours for that. There was a section that was on locks and strikes, which was appropriate for access control. There wasn't a specific request for the number of continuing education hours on that.
They told me 16 in an email. I thought that I sent that with it, but they wanted
16 for the whole course. I feel like that would be inappropriate. I would feel like that probably 5 hours for the courses that were submitted, which would exclude the portion that was the 2014 NEC update for alarms, would be much more appropriate. So I would recommend that we approve the course as they've submitted it for 5 hours rather than the 16 hours of continuing education they've requested.
What I believe they'll probably do is come back and resubmit and revise that. And I think they're going to come back and probably offer separate modules.
That would make a lot more sense, frankly.
I kind of thought so too, but then we'll relay that. So your recommendation is to approve it for 5 hours.
I would approve
and
the
leave out the NEC update for alarms.
Right.
Period.
Right.
You want to vote on that one since it's changed, or?
Either vote on them all at the end, or we can vote on that one and then vote on the elite one. Either way.
Let's go ahead and vote on this one so that it's in the record on the 5 versus the 6.
I made a motion, so you need a second.
All right, we need a second.
Second.
Okay, Mr. Roberts has made the motion. Mr. Harvey seconded for 5 hours of continuing education from at-home prep instead of 16. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Next courses on your list, and I will probably have to stop in the middle. We're from Elite CEU. We had several 1-hour courses and a few 2-hour courses. I'll read these into the record. Did anybody have any questions about the Elite courses?
I didn't get to look at all of them because I didn't think I'd be here, but the ones I did look, you'll figure out.
I mean, they have so many courses we've approved at this point, and then they'll take some of these and combine them into a bigger course. But if there weren't any questions, let me read these into the record, and then we can have a motion. Advanced Perspective of Commercial Application and Layout is 1 hour. They submitted it for employee training and continuing ed, but it's not suitable for the level 1 equivalent for employee training. But since they checked that box, I had to put it on there. So I'm going to think that the recommendation is going to be for continuing ed only. Okay. All right. The second one is an advanced perspective of residential application and layout. It's 1 hour. The third one is an advanced perspective of system programming. It was 1 hour. An expert approach to commercial interior detection. It was 1 hour. An expert approach to commercial perimeter detection, that was 1 hour. Applications of electrical theory for alarm professionals, that was 1 hour. For that one, they also included initial app, which I didn't believe it was sufficient for, but I'm gonna assume, or will y'all clarify, it's only for continuing ed. Next one is best practices in troubleshooting burglar alarm systems. It was 1 hour. Detection devices and specialized applications, 1 hour. IP survival kit, it was 2 hours. NFPA 70E standard for electrical safety in the workplace, it was 1 hour. Output device proficiency, 1 hour. Practical guide to control panels, 1 hour. Professional customer service for alarm technicians, that was 2 hours. Proven approaches to system power needs, that was 1 hour. Z-Wave wireless basics, that was also 1 hour. And Z-Wave wireless implementation, that was 1 hour.
So are you recommending all of these elite courses just for continuing education? None of them for
I don't think
employee
it, well,
training?
it's
and-
really up to you guys, but again, they don't meet the requirements for initial app or for employee training.
Okay, so in mass, it's just for
Yeah.
continuing education?
There's not a, we don't get any content really. It's an overview. I mean, all of them look sufficient for the hour, and some of them might even be sufficient for employee training if the testing part was there. But, I mean, they might, but that's the problem. It's the
Well, they have a
issue.
couple of courses approved for employee training that are
Okay.
comprehensive courses that they have to go to PSI and take a proctored exam to complete. I don't know why they keep submitting them this way. I've explained to the girl that the employee training has to be comprehensive level 1 equivalent. Again, it's up to the board, but I could only see continuing ed for these particular courses.
That being said, do we have a motion on the elite CEU courses?
Is there ever, I mean, is it something where we can request more content, or more information, or, I mean, I'm okay with all these, and I'm just thinking more in general. Because a lot of times what we get is very brief. We don't know, they may have a line item on there that's, that sounds good if that's a 15-minute part of but if it's one question on the test or something, it may
Right.
not.
Well, again, when they did their comprehensive, when they presented and got approval for their level 1 equivalent and for their other courses, they actually came before the board and brought almost all the materials. And it took 2 meetings for it to get approved, just because the board didn't feel like their online was equivalent, and then they added and changed it around and came back and got it approved. I mean, I think they'll do whatever we ask them to do. We just have to tell them what you expect. Want more information on these, or just in the future?
Not on these. If we move forward with continuing education on all of them at an hour, I think their times are reasonable. Sometimes they've submitted stuff that was for a lot more hours without seeing content. I hate to approve something for a bunch of hours on some of these,
Right.
but for an hour on any of them, I'm fine with all of those. So do we need to do a motion on those? I would make a motion to approve all the 1-hour courses for elite CEU as continuing education, but not employee training.
There was 1 2-hour course in there. The professional customer service.
Or the IP survival kit
Right.
also? So are you okay with those for 2-hour courses?
Show more content on that one.
IP survival
Yeah,
kit.
or more, a longer synopsis.
Approve them all for 1 hour and leave it at that.
I second with discussion. He wants to look at the IP survival kit just a second. Here it is. My second stands.
That is to approve them for 1 hour each,
For their requested hours.
for the requested for continuing in. Okay.
Okay. Mr. Cockcroft's motion was seconded by Ms. Jones on these for 1 and 2 hours for continuing education. All in favor, voice by saying aye.
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 All opposed? Okay, the
The
motion
next
passes.
one was actually a 4-hour course submitted by Hick Vision USA. I know most of you are familiar
Hick
with
Vision.
Howard Constam, but Howard has put together a 4-hour course called Nuts and Bolts Technical Training that he has been offering as part of the camera systems he's now selling for Hick Vision.
Like take a hike in the
Hike
woods.
Vision,
Yeah.
well,
Hike
I'm just
Vision.
looking at the way it's spelled.
I know, that's what the
How would I
customers say
know?
too, but it's,
It's
Well, it
Hike
depends on whether
Vision.
you're hick or whether you're a hike.
Well, I'm a hick, so it's okay. I'll try to remember that.
There's
I'll
no
put an
C.
E on my notes. Hike Vision.
Remember, there's no C in there, so,
Chinese company.
Um,
so-
I thought
right.
it was my company.
Is it a Chinese company?
I know.
Okay. Were there any questions about that particular 4-hour continuing ed course?
Madam Chairman, I reviewed the course material that was presented and felt like it was perfectly appropriate for 4 hours of continuing education. Looked like a well-done course.
Okay. We have a motion by Mr. Roberts, a second by Mr. Harvey to approve this for 4 hours of continuing education, nuts and bolts, technical training. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next is Stay Safe Enterprises.
And that was put together, I believe, that's a Comcast derivative. Let me look. Trying to find it. Anyway, there's the Hick Vision. Stay Safe Enterprises was submitted by Roy Pollock, who is now with Comcast. And he's put together a course called NEC for the Low Voltage Contractor, and he's requested 2 hours. He's requested it for employee training, initial app, and continuing ed, all of the above. I really don't think it's suitable for anything but continuing ed. Did anybody have any questions about that one?
Madam Chairman, again, I reviewed the course materials presented. I did not feel like it was appropriate for initial application, potentially for employee training, and certainly for continuing education for 2 hours. Unlike the course that I had a problem with a few minutes ago, this course was targeted directly towards the alarm industry and looked to be reasonably well done. So I would make a motion that we approve the course for the 2 hours of continuing education and also employee training.
Okay. Go ahead.
If you approve it for employee training, they're gonna have to have 14 more hours of a comprehensive equivalent to level 1 to go with it.
Right. Like I said, I felt like the course was appropriate in the 2 hour measure for that, but
maybe
yeah,
try to
that's
build
not going to be an adequate course by
employee
itself for employee
And if I
training.
put it on the approved employee training list at 2 hours, then somebody's gonna take it and say, there it is, I've done my training.
Is there a requirement for hours on the employee training? And
Gotta be the equivalent of level 1, NTS level 1, which is
All right.
basically 16 to 24-hour course.
I would see it okay as, two of the, or what's the request but 2 of the 16 hours, but if it's not written that way, we can't.
All or nothing?
The way it's worded in the statute, it's all or nothing.
Madam Chairman, let me restate my motion, if I may, that we approve the NEC for the low voltage contractor for 2 hours of continuing education.
Okay.
They might be trying to build 16 hours to make a class or something, but is there a way, can we?
Well, again, if it's approved for continuing ed and they resubmit it in a format that would include 16 hours, we would approve it that way. I'm just real hesitant to put a course on the employee training list that doesn't meet the requirements by itself,
Right.
just because of the way the law's worded, but.
'Cause we definitely wouldn't want it for just that one course for.
No, certainly not. Need a second to that motion.
A second.
Okay, we have a motion by Mr. Roberts to accept this for continuing education only, the NEC for the low voltage contractor, and a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next one is the Seymour
Seymour
Group.
Group, they had several courses. The first one was structured wiring, components and tools for 1 hour. Structured wiring installations for 1 hour. Structured wiring introduction to structured wiring for 1 hour. Structured wiring terminations for 1 hour, and structured wiring testing for 1 hour. These were all submitted for continuing education only.
Madam Chairman, I carefully reviewed the materials submitted on these. I felt that they were perfectly appropriate for 1 hour each of continuing education. So I would make a motion that we approve these courses for each 1 hour of continuing education.
Okay. We have a motion by Mr. Roberts, a second by Mr. Harvey to approve the Seymour Group courses as presented, 1 hour continuing education for each. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Madam Chair, let's go back, if you don't mind, to our 9:30 budget review. Our Assistant Commissioner and County Manager are here for their presentation.
Thank you.
Morning.
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 I'm Brian McCormack, Assistant Commissioner, Commerce and Insurance, and I have with me Bill Hiddleston, the Accounting Manager for the division. And we wanted to take a moment. We, and before I was here, now Deputy Commissioner Jeannie made it a practice to come before you and just talk about the general state of where your financial standing is. And so we wanted to take an opportunity to review that. I believe you all have a copy of the. And I'm pretty confident that Cody has went over this with you before, but what I'll do is kind of give a sort of a high-level overview and just, to kind of stir some thoughts with you all as you look over the budget. But if you look at your payroll expenditures, were down a little bit in FY 14-15, and then looking at your other areas of total expenditures, they're down pretty significantly to $300,000 compared to the previous years. And I think one of the things we noticed was related to expense related to some of the computer related items, related to state professional services. There's been a pretty good drop off there, which was kind of the main area there, and with some of the reductions in payroll and you had your expense to PSI was up last year. So, but generally that's your grand total expenditures were $300,000. The cost backs, which are attributed to you based on your portion of the cost that shares with the other programs, of how much you all owe for overall administration. You can see from previous years. From last year, you're down. I think you're in a generally good place in terms of your cost back, which is a reflection, I think, of good management by your program's administration. That takes you to a total expenditure for FY 14-15 of $479,760. Looking at licensing revenue, you all have a slight one high year, low year, just a slight up down year as you go forward, and so. We like to compare to the a 2-year cycle, and so you're doing pretty well. There seemed to be a little bit of a dip last year in terms of revenue, but if comparing the other FY 15 and FY 13, you can see that it was actually somewhat of an increase. So I think that's a good thing for you all. Your total revenues were at $786,748. And that leaves you with a fiscal year balance of $306,988 which if you add that to your prior fiscal year reserve of $911,000, that puts you at $1,218,603. And so you're all obviously in a good spot in terms of your overall financial standing. I think one of the things that I do want to just make note of here in terms of your overall reserve balance, we ask that programs maintain a 2-year operating expense in terms of so your overall expenditures. We kind of ask that you'd have about 2 years in terms of to make sure that if something occurs, you've got that healthy reserve there. I will point out you're starting to accumulate above that, I think. So it's just something that I think you all want to continue to keep an eye on, because that reserve is growing and growing, and so we want to make sure that we're not, that kind of thinking about the idea of looking at, your fees and other things that could determine how you're spending the licensee's money. And so I think what the great thing is when you're adding to your reserves, it means that you're running your business very efficiently, and I think that's a really good thing, and I think it's a good reflection of what Cody and her team is doing as well. So that's my general overview. I'd be glad to answer any questions about this or any other subject area y'all like to discuss.
Other than the comment that I would agree with your comment that I feel like that our staff does an excellent job of managing the cost of the operation of this board. I think they do an excellent job as well, and I'm glad to see that that's appreciated in other locations within the Department of Commerce. Thank you. I take it as a compliment that we're doing it right.
Yeah.
And especially Cody.
That's right.
Of course, I'd also point out that Cody has an excellent staff that has been with her for a number of years, and has really, I feel like that their previous experience and expertise probably is a significant factor into streamlining the overall operation and allowing it to operate as efficiently as it does.
And I any chance I get and I think Cody's someone who's done a good job for a number of years, and I'm grateful to have her, and I think she does a great job, and her team I think that's a great point, is her team does an excellent job as well. And that's one of the things I like when we're in a good place. I always like to get to say that and to the boards so they can know really what a good job their staff's doing. So I appreciate your comments.
Huddleston, were you going to speak too?
Not me, not today.
You're just the
Don't want to
backup.
listen to me.
You're just the backup guy.
Yeah, he's my backup here.
Innocent bystander.
Okay. Thank you for your presentation, and thank you for coming down.
Thank you all.
Bye-bye.
All right, Madam Chair, if you'd like, we'll just go ahead and continue. We're going to go back up to the legal report now, please, for our attorney.
Oh, yes, I'm sorry.
Okay, I'm sorry.
Okay.
Okay,
Yes.
we'll go ahead and jump right in. The first case is 2015-022-062. This complaint opened when the board office received termination notices more than 30 days after the employee termination dates. All of the termination notices were received on June 15th, 2015, with the following termination dates for registered employee 32202. The termination date was February 18th, 2014. Employee 27654, termination date November 14th, 2014. And registered employee 32387, the termination date was December 3rd, 2014. The respondent apologized for the failure to timely submit the terminations to the board office. The respondent states that the error was discovered during an audit and termination notices were submitted immediately thereafter. My recommendation is to authorize formal and send a consent order with a civil penalty in the amount of $150 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K, the amount representing $50 for each employee.
Madam Chairman, I make a motion we concur with the recommendation of our council in this case.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2 is 20150214571. I'll note to the board now there's a slight edit in the penalty calculation, but I'll go through the summary and give you the corrected version. This complaint opened alleging that responding company failed to register the following alarm employees within 30 days from the employment date. Registered employee 33326 and 33328. They both were hired on November 17, 2014, and the applications were received on May 1, 2015. The responding company responded to this complaint and stated that an employee that was handling licensing at that time separated from the company and missed the application submissions. Once the responding company replaced the position, an audit was performed and the applications for the above-mentioned employees were then submitted. Responding company did apologize for this oversight. My recommendation is to authorize a formal and send a consent order with the civil penalty in the amount of $1,000 for violation of Tennessee Code annotated 6232312C, representing $100 per month for each unregistered employee.
Council.
Hey, we have a motion by Mr. Harvey, excuse me, and a second by Ms. Jones to concur with our counsel in this matter. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
Case number 3 also has a slight edit in the calculation. The case number is 20150213901. This complaint opened alleging that responding company failed to register the following alarm employees within 30 days from their employment dates. Registered employee 32883, the employment hire date was October 2nd, 2014. Employee 29787 with the hire date of June 22nd, 2014. And registered employee 32882 with a hire date of June 30th, 2014. The applications for those 3 employees were received on February 24th, 2015. The board office also received a transfer form for registered employee 17434 on February 24th, 2015, after the employee was hired on June 30th, 2014. Responding company responded to this complaint and stated that a former administrative person failed to send the paperwork to be completed, and this administrative person no longer works for a responding company. The responding company states that they corrected the issue as soon as they became aware of the situation and apologized that the oversight occurred. In this case, I recommend authorizing a formal sending consent order in the amount of $950, the amount representing $900 for violation of Tennessee Code annotated 6232312C for the 3 employees and their registration date, and then $50 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K for the transfer form.
Okay.
Are all these employees, do y'all move forward with the licensing? Are they registered employees now? The employees
Process their
they're
application.
in,
Usually the applications are what alerts the board office to that failure.
but they haven't been on hold or anything. They move forward, okay.
Madam Chairman, I make a motion we concur with the recommendation of our council in this case.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
By Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 4.
Okay, case number 20150214261. The board office opened this complaint when the respondent failed to submit a registration for a registered employee within 30 days from the employment date. The employment date was listed as June 2011, and the application for employee registration was received on March 31st, 2015. The company responded by saying it misunderstood Tennessee Code annotated 6232312. Respondent states that his understanding of the statute was that certified alarm contractors were not considered employees as they are employers, and based on that understanding of Tennessee Code annotated 6232312, that statute would not apply to the respondent company. Respondent states that the company has been recertified numerous times since 2011 and no employee was ever listed. Respondent states that the present issue was not addressed until the employee requested to change her name on the alarm contractor certificate. The respondent did apologize for misunderstanding the statute and takes responsibility as the qualifying agent. In this case, I recommend authorizing a formal, sending a consent order with a civil penalty in an amount up to $2,200 for violation of Tennessee Code annotated 6232-312. The maximum civil penalty amount in this case is usually calculated. This would be the first violation. Will be $50 per month for each employee that was not registered. There was one employee. It goes back to 2011. So $2,200 would be the maximum amount, but I'll leave it to the board to consider.
So does he have any validity in his argument that they've been recertified all these years, but it was never, no employees were listed? I mean, was this just an oversight that they got by
We do
with
get
it?
companies that come in and say they don't have any employees in Tennessee.
Oh, okay.
License the company. That's what this company told us year after year after they renewed.
Okay.
Then all of a sudden, here this company, and you go, wait a minute, how long has this person been working?
Okay.
So, and there is still a qualifying agent? There is still, so there's a qualifying agent but no employees?
No registered employees.
So from this application, we would understand that they now have a single employee?
Yes, that's the way it came in, I believe. That's a board office question, but from,
Yeah,
Yeah, go ahead. You can explain
She's
it.
the owner, but go ahead.
It's the company owner, and she thought since she owned the company, she didn't need to be registered.
And she's not the qualifying agent?
No.
Oh.
And the QA thought that too, apparently. No, she does all the
Difference what
sales.
type
Okay.
it is.
Is it a small company?
Yes.
Doesn't make any
It
difference.
doesn't matter.
Well-
The only reason, and I understand that that doesn't make a difference, the only reason I bring that up is it seems like there are a lot of monitoring companies listed with either no or one employee, and that does seem like that makes a difference from the standpoint of, we know you can't run a central station, you can't monitor with one person. That doesn't, right.
Every time I bring that up
That's right.
in talking to these companies, and there are several that have Tennessee licenses that really haven't got any accounts here, that's what they tell me. Got the license thinking they would have some accounts here, but they,
But that's the only reason I brought that up, but that doesn't apply, or it,
Okay. Any more questions or discussions on this?
I'll make a motion to concur with council.
Okay, we have a motion by Ms. Jones to concur with council. Do we have a second?
Just while the board is considering, I know my recommendation was up to $2,200, so I just think the motion should include an amount if you're going to assess a civil penalty at all in this case. Because like I said, we first found out about it, I guess, this year, or I'm sorry, March of 2015, but it goes back to June 2011, so
first offense.
it is a first offense, and at $50 a month, that would come up to $2,200. So I didn't know exactly how the board wanted to proceed on that, with this being the first offense, so.
Madam Chairman, I guess I personally am just a little bit uncomfortable with the magnitude of this recommended, well, actually, the recommendation is a civil penalty up to, as it was pointed out, and I guess I'm just a little bit uncomfortable with this. I feel like that I would be much more comfortable with a civil penalty significantly smaller. The indication would be that this appears to be an honest misunderstanding, a first offense, and am I correct in that the respondent here seemed to be reasonably forthcoming and was straightforward in what they were indicating here? Is this?
How many years were they licensed without this employee?
2011.
I'm sorry.
No, it's not without this employee.
They didn't.
They
The
didn't
company was
register.
originally licensed in August of 2011.
Qualifying agent and has the whole time, their owner.
They presented to us that they never had a
And-
registered employee. In
That
fact,
employee
they
tried to
did.
change her name. That's
That's-
what prompted the board office.
Then we found out they've had an employee working since 2011.
My recommendation was because it looks like there's just complete disrespect for the law. If you got a QA, that means you read the book, and you got a QA, and you got your company licensed, and then you know you're supposed to have your employees registered. That's where I was coming with that. If you want, we can change my motion to a different amount, because I've not said an amount yet.
Yours, what I've got's your motion, but I don't have a second,
No,
and then
it's not
Ken
been-
made a motion.
It's not been
No,
said.
no, I'm sorry, I did not
That
make a
was-
motion,
You
it
made
was
a
just a
recommendation.
comment.
A comment?
Did anybody second Karen's
No.
motion? I didn't think
Ms.
so.
Jones has a motion on the table to concur with council's recommendation for a civil penalty of $2,200. Do we have a second on that motion?
If we have a second with discussion, we can change the amount.
Let's qualify that. The recommendation is for an amount up to
Yes.
$2,200.
And that's at $50
So-
a month for the number of months that they went unlicensed.
And there's
Or
our-
unregistered, I'm sorry.
As our council pointed out, that was an up to figure, and
So, Ms. Jones, are you saying that your motion would be for the $2,200 being $50 a month for the employee?
Yes, ma'am, mine
Okay.
was.
I was
But we can second with discussion and change the amount.
Okay, I'm sorry.
Do we have a second on Ms. Jones's motion, or do you want to let it die for lack of a second?
I'll second for discussion.
Okay, second by Mr. Cockcroft for discussions.
Is
Go
there
ahead.
anything in the record that shows that this person was the owner, or that they were, I mean, I don't know that our application or process shows who the owner of a company is, does it, or is it? So was she on that? Did we have,
Listed on the company application, but their roster of employees didn't include her.
she could own the company and not necessarily be required to be?
A lot of people own companies that really don't have any day-to-day involvement.
Right, and they don't work there.
But she is the only salesperson. So,
Madam Chairman, I would make a motion that we amend the current motion.
Got a motion and a
wait.
second already.
we've got a
I
motion and a
understand,
second.
that's the reason I'm proposing an amendment.
Okay.
I would move an amendment to the motion that's on the floor, that we set the amount at $1,500.
Dollars times what?
$50 times the number of months. If you take $1,500 and divide it by 50, then it would be for that number of months.
All right. Okay, so it's gonna be
was their
$50 for
I think
30
you're taking
months.
that new math where any answer's right.
So
So now that you've made a motion to amend, you have to have a second to amend, and
Yes,
then
it
you
would take
vote
us-
on the
it would-
motion as amended.
Yes, the procedure would be that my motion for an amendment would take a second. If that second is forthcoming, then you would vote on the amendment, and then you would vote on the motion as amended.
Okay, perhaps I can clarify that a little bit. If you did $50 since the last, $1,200, $50 per month since their last renewal.
Let me restate my motion, if I may. I would offer an amendment to the motion that's on the floor, that we set the civil penalty at $1,200.
Okay. Okay, we have an amendment by Mr. Roberts to amend the civil penalty to $1,200, which has been seconded by Mr. Harvey. So with that being said, all in favor voice by saying aye.
Aye.
All opposed?
All right, then let the record show we did on this one here, number
No, wait a
4.
minute. Now, we need to
Oh,
vote,
did we not
that
vote?
was the amendment
That
that we
was just
voted
voting on
on.
the amendment.
Now you need to vote on the
Original
motion as
motion.
amended.
Now to the original motion to concur with council with the amendment already passed, correct? All in favor voice by saying aye.
Aye.
All opposed? That motion carries, the original with the amendment.
Decide on number 4 that we, with the amendment, we are going to go $50 a month for 30 months, which is
That's
24
just
months.
since the last renewal.
Which is since the last 2013 renewal.
Okay. Next,
Case number 5 is 2015-021-3451. This is a consumer complaint alleging that complainant requested cancellation of her alarm contract, but responding company never canceled her service. Complainant states she signed a 36-month contract with a separate company on May 13, 2011. Complainant states she paid her last 3-month installment on October 1, 2014, including a letter to request cancellation of her services. Complainant states that responding company and another alarm contracting company merged, and her account was no longer being withdrawn for services, so she assumed her account was closed. Then in June 2015, complainant received an invoice, and then in August 2015, complainant received a collections notice for $242.55. Complainant immediately called responding company and stated she could not get through, so then she emailed. Complainant states she sent 3 more letters stating her account should have been canceled with no response from responding company. Complainant was upset that her account was in collections and paid the $242.55 with another letter stating her account should have been canceled. Complainant states she never received confirmation of cancellation from responding company. Responding company states that complainant account was included in a merger that occurred in September 2014, wherein her payments were to be drafted quarterly. Respondent states that 3 payment drafts were attempted and all were declined. Respondent then mailed an invoice, which was returned with a message from the complainant regarding canceling service. Respondent states that complainant signed a 36-month agreement, which renewed automatically for successive 2-year terms unless a 60-day termination notice was received. Respondent states that complainant submitted 2 additional written letters requesting cancellation. Respondent stated that although the complainant was under a successive contract term, the complainant's contract was canceled upon her final payment of $242.55 rather than the scheduled end of the contract being May 13, 2016. Respondent states that it is not company policy to respond to written requests for cancellation. However, complainant's account was canceled and no further billing was issued. My recommendation was closure as there was no violation found by the respondent in that they were following the terms of the contract that the complainant did sign.
Madam Chairman, I make a motion that we concur with the recommendation of council and close this particular issue.
Second.
go ahead. We have a motion by Mr. Robertson, second by Mr. Harvey, but
I wanted to ask a question, in case I ever want to install an alarm system at my house. Respondent states that it is not company policy to respond to written requests for cancellation. How do you cancel it then?
I noticed that also.
I personally thought that was crazy,
Okay.
but
Well, contractually, if you send it in 60 days prior, according to the terms of the
writing.
contract,
Yeah.
they don't have to respond to it. They just have to complete the
Right.
action. And so I think the respondent is arguing in that point. She sent us these letters, but it's not our policy to respond to those letters. If we get the cancellation notice within 60 days,
How do you know it's canceled?
no, you can send the letter to the company. The company does not have to respond to you.
Then why do they charge you $242.55?
Because her request to cancel did not come within the 60 days.
I'm just making a point here.
And I
just
understand what you're saying, your
don't-
frustration. I don't think they should necessarily have to respond to the cancellation, but if they're not going to cancel it, which is kind of what they did, they
should tell them they're not
ought to
gonna
respond
cancel
to
it.
that. But I can understand not responding to a cancel. I mean, if you cancel your phone service or cable service, they may not respond, but they also quit sending a bill.
Right, they turn it off.
And if they say you still have a contract, they should respond to that. But that's still not something that we really have any
I was just
control
making
over.
an
It's kind of
observation.
it's a contractual or
I
civil
was just
matter.
making an observation. I didn't know how to cancel my contract.
But I think you're right. If they didn't cancel it, they should have responded and said something. But
and
that's-
and especially considering or assuming the complainant's allegation is correct in that she had tried a number of times to cancel this and apparently did not get any response from the company. I really was quite disappointed in their behavior in that point. But nevertheless, I felt like the recommendation was appropriate. The matter seems to have been resolved. Was there a second to my motion?
Yes, you, and then Keith. All in favor, voice by saying aye.
Aye.
All opposed? The motion to concur with council passes.
Case number 6 is 2015-021-4201 and 2015-021-4202. This complaint was opened when the board office received notification that respondent 1 failed to notify of the qualifying agent's termination within 10 days. Additionally, respondent 2 failed to notify the board office of his termination. The board office received notice from the company on February 3, 2015 regarding the termination of the qualifying agent and requesting an extension to obtain a new qualifying agent. Respondent 1 states they ceased as a business entity on December 31, 2014 and no longer does business in the state of Tennessee. Respondent 1 is now owned by a different company. The new company states this was an oversight and the termination notice was lost in the reorganization of its business units. Respondent 2 states he failed to submit the proper paperwork during his resignation because it was a hectic time, and this was an oversight on his part and apologizes. Respondent 2 submitted a termination notice in addition to his response with the complaint. As to Respondent 1, I recommended closing and flagging as the respondent is no longer in operations in the state of Tennessee. As to Respondent 2, I recommend authorizing a formal and sending a consent order with a civil penalty in the amount of $50 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.06 subpart 8.
And this is for the QA for failing to send in his termination notice from that company. Okay, thank you.
I make a motion to concur with our recommendations from council.
A second.
We have a motion by Mr. Cockcroft and a second by Ms. Jones to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. It was Scott and Karen.
Complaint number 7 is 2015-021-693. This is an anonymous complaint alleging unlicensed activity by respondent. The complaint alleges that respondent is selling and or installing CCTV without being properly licensed. In the complaint, photographs of respondent's website were included, which showed that respondent provides, quote, surveillance cameras and closed-circuit televisions. Respondent's website does not indicate whether the cameras sold are monitored by the company. The respondent offered no response to this complaint. My recommendation is authorize a formal and send a consent order with a civil penalty in the amount of $600. The civil penalty representing $500 for violation of Tennessee Code annotated 6232304A, and a $100 civil penalty for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.07 subpart 14 for failure to respond to the complaint.
Council.
I have a question. They're not licensed in Tennessee, is that correct?
That's correct.
So anywhere in there, are you going to send them a cease and desist letter? Is that included?
I can include that if you change the
Along with the
I will
civil
include it.
penalty?
Absolutely.
Okay. All right, with that being said, we have a motion by Mr. Harvey to concur with council. Do we have a
I
second?
got another question.
Okay, go ahead.
Is the company, do they actually exist, physical address, or is it just a website, e-commerce?
Like, are they in Tennessee? You know, are they?
I don't recall. I don't have the file in front of me. I believe that they. Do you recall, Regina? I think they.
They actually do have a physical address.
I believe so. Mm-hmm.
I second.
Okay. Motion by Mr. Harvey, a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Case number 8 is 2015-021-4301. This complaint was opened by the board office alleging that the respondent failed to submit a transfer form for an employee. The employee's hiring date was May 17, 2014, and the transfer form was received by the board office on March 31, 2015 through a new qualifying agent. The respondent states that the employee was initially hired as a cable person and not of the security division of the company. Once the employee was promoted to the security division, he was then registered correctly by the new QA for the company. I recommended closing and flagging as the respondent's license had expired.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Okay, we have a motion by Mr. Roberts. Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Now, the respondent, is that the company or the QA?
A QA.
And his license or
The-
her
the-
license are expired?
Yes, ma'am. The person for whom the transfer would have been received, yeah.
Okay.
Case number 9 is 2015-021-3971. This complaint opened alleging failure to submit termination notices for the following employees within 30 days from the termination date. Registered employee 29098 and 29099. Both of the notices were received on March 13, 2015, alleging termination dates of April 30th, 2014. The respondent states that registered employee 29098 left their company and registered employee 29099 is still employed by respondent company. Respondent states that neither registered employee have worked in Tennessee since 2014. Respondent states that their continued employment in other states caused confusion on the documentation of their termination dates. Respondent states that the March 13, 2015 date is the date when the respondent confirmed that the employees would not be working in Tennessee. The termination forms are dated March 13, 2015, being 2 days prior. I think I put it right the first time. Let me read that sentence again. Respondent states that the March 15, 2015 date is the date when the respondent confirmed that the employees would not be working in Tennessee. The termination forms are dated March 13, 2015, being 2 days prior to respondent's stated termination date for the registered employees. My recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $400 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K. Civil penalty amount representing $200 for each employee termination notice not received timely.
I'm going to understand, the employees still work for him. They just don't work in Tennessee?
One does, yes, sir.
I don't
Yes.
think we should penalize him for having said when he wasn't working in Tennessee. I mean, he still worked for the company, but the other one, though, was actually terminated at that date, or?
Yeah, he said March 15, 2015 is the day they confirmed they would not be working again in the state of Tennessee, rather than the date they discontinued any work in the state.
But the first employee was actually terminated from the company in 2014, but they didn't send the termination notice in for an additional 11 months.
What's the typical, what the penalty for that? Is there a
Well, for this, this will be termination. It will be per employee, but this was the third violation for the same statute, which is why I did 200 per employee.
I would second Scott's motion.
I didn't make a motion.
Oh,
No, he didn't make a motion.
I'm sorry.
Fix that.
Why don't you do that? No.
Just to the one employee
As
then?
far as to do for $200 for one employee? Is
Okay.
that what? you-
No.
So I would
You've
make
got
a,
that other employee that,
$200 for each employee.
yeah.
Well, since there's not a motion on the floor, I'll make one. I make a motion we concur with the recommendation of council.
Okay. We have a motion by Mr. Roberts to concur with our council's recommendation. Do we have a second?
Second.
And a second by Ms. Harvey. All in favor, voice by saying aye.
Aye.
All opposed?
I never made a motion. I just,
He was
Yeah.
just discussing.
I was just asking a question, so just to
I
clear that up.
apologize for
That's okay. That's okay.
misunderstanding. I agreed with your question, however.
Okay.
He was asking a motion.
Okay, case number 10 is 2015-021-4141. This complaint opened when the board office received notice that the respondent failed to register the following alarm employees within 30 days from the employment date. Registered employee 30893 with a hiring date of July 14, 2014. Registered employee 33060 with the hiring date of August 2014. And registered employee 33058 with a hiring date of June 15, 2014. All the applications were received on March 31st, 2015. Respondent states that its primary business is installing cable, internet, and phones. Respondent states that once an employee is determined to be a good candidate for the alarm portion of the business, he or she begins training, which occurred with the instant employees in this complaint. Respondent offered no additional explanation as to the registered employees and their hire date within the alarm industry. I did make that request while investigating this case. My recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $1,050 for violation of Tennessee Code annotated 6232-312C, calculated at $50 per month per employee.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 11.
Okay, which is case 2015-021-4721. This complaint alleges that respondent failed to list registered employee number 19010 on the company renewal form, which the board office received on April 7, 2015. The board staff has not received a termination notice for him for the registered employee. The respondent offered no response to this complaint. I recommend authorizing a formal sending a consent order with the civil penalty in the amount of $150 for violation of Tennessee Comprehensive Rule and Regulation 0090-01-.069K. That would be for the failure to submit the termination notice. And then $100 for violation of Tennessee Comprehensive Rules and Regulation 0090-01-.06, subpart 13, for failure to respond to the complaint.
Is that consistent with what you did in the previous one on failure to respond?
The $100, yes, ma'am.
Okay.
Standard.
Mm-hmm. It would be $50 for failure to submit the termination and $100 for failure to respond.
Okay.
Make a motion to concur with council.
Okay, we have a motion by Mr. Harvey to concur with council. Do we have a second?
That's not what it says in here, is it, as far as the total? Am I on the wrong one or reading it wrong?
What, 150?
No, it's just
It's the
laid
page
out a little
7.
different. 50 was for the first violation and 100 was for the second violation.
Yes.
I second the motion.
And second by Mr. Roberts to concur with council. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 12.
Okay, it's case 2015-021-551. This is a consumer complaint alleging unethical and unprofessional conduct by respondent company. Complainant alleges that respondent offered him 30 days free service with the alarm system. Complainant states he never signed a contract with respondent company. The complainant alleges that respondent company mistreated him, damaged his home, which cost him hundreds of dollars in repairs. Complainant says the company installed a thermostat to go with their system pad, which caused his furnace to stop working and cost him $200 to repair. Complainant states that that should say respondent. No, complainant says he told respondent company that he no longer wanted their service and they ripped their system pad off his wall, leaving a golf ball-sized hole. Complainant says the company disconnected his alarm altogether and he can no longer utilize his existing pads or sensors. Complainant states that respondent ignored his attempts to file an internal complaint. Respondent states complainant initialed and signed a 60-day an agreement to 60 months of service with the company. Respondent also states that the complainant took a recorded survey wherein he admitted to the 60-month agreement and also agreed to the automatic payment and service warranty. Respondent states that complainant was aware of the contract prior to the installation of equipment and or the service. Respondent states complainant canceled within 3 days and the security system was removed from complainant's home. Respondent company says the agreement contained a limitation of liability and limited warranty. Respondent company says the complainant decided to change his mind and have the system removed, which did leave a hole and they are not liable for those damages. I saw no violation based on the evidence, and so my recommendation was closure in this case.
situation's unfortunate that they had damage, but it does look like the respondent complied. I mean, he did the right thing. He canceled the contract within the 3 days, and he.
More than likely didn't rip it off the wall, but when
Right.
you take it down, you got a 2-inch hole saw.
You're going to have a hole behind
Hole.
anything you take down.
They could have stapled it up the wall. Could have been worse.
So I would make a motion to agree with the recommendations of our council.
I'll second.
Okay, we have a motion by Mr. Cockcroft and a second by Ms. Jones to concur with the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case 13 is 2015-021-3691. This is a consumer complaint alleging unethical and unprofessional conduct of respondent company. Complainant states she was solicited for an alarm system by respondent company when a salesman was going door to door in complainant's neighborhood. Complainant states that since installation, her system has gone off several times, erroneously alerting the police and fire department. Complainant states that she had reservations about contracting with respondent company and she went to her bank to stop payment on the check. Respondent states that she found out that the amount of the check was changed from $49.99 to $54.56 and the check cleared. Complainant states she closed the account as a result. Complainant states she is removing the system from her home and returning it and has contacted an attorney. Complainant says she feels like she was scammed and felt uncomfortable in her home with the system in it. Complainant states through conversations with local police and neighbors, she was told that the responding company was a scam. Complainant states the local police told her they forced the responding company out of town because they were scammers. Responding company says they were not run out of town by police. Responding company states the complainant has no evidence of the alleged scams. Responding company says they offered to install a new sensor despite complainant's past due balance, and complainant responded by saying she would call back with her attorney and disconnected the call. Respondent company states complainant has not made a payment since her services began on August 4, 2014, and she currently has a past due balance of $803.42. Respondent company states that it will not cancel her services or forgive her past due balance, as complainant has been in possession of the equipment and has received services without making payments. Respondent company offered a settlement to the complainant in order to be released from her contract. I recommended closure as the issue between the parties rises to a contract dispute rather than a violation of our statute.
With council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second? Second. And a second by Mr. Harvey. All in favor, voice by saying aye.
We can talk about it for
Yeah.
just
Okay.
a second. It seems like this goes to back to the. I mean, I understand the contract dispute, but it seems like it goes back to the door-to-door. But if it is misleading or evidence that the check was changed and some of these other things, that's.
I also had a concern about the alleged change in the
Check
checking
amount.
amount. That seems quite unusual.
It almost like they attached tax to it, you know, for the difference in it's like they attached a state sales tax to it.
But how do you change the amount of a check and still have it clear? That seems pretty strange. Well, I feel like that our council has properly recommended that this is a contract dispute between the two entities involved, and does not appear to be any clear evidence that's been presented thus far of unethical or unprofessional conduct. So I believe I'm going to have to vote in favor of the motion when we vote on it.
$49.99 and 9.75 in my county. We did add tax to it.
A lot of the
'Cause they got
services
54,
now has
56.
sales tax.
Get a check and then you process it electronically, they charge you extra money just to
If she
process
signed a
it.
check and
She
they
did sign
signed
the
it
check.
and they run it through a
And she
machine, then it prints the other
It
information.
should have been the same amount.
I don't understand, you know, how it changed, how she wrote the check for one amount and it cleared for a different amount, that part. But
She's had to
again,
initial
I
it.
don't know that it's anything that we've got any jurisdiction over. You know, if they they changed it, that would be something for the police to investigate for a criminal matter. But anyway, we have a motion, we have a second, and we're in the midst of voting on that motion. So all in favor, voice by saying aye, that you concur with the council's recommendation.
Aye.
All opposed? Okay. The motion carries.
I apologize. Case number 14 is 2015-020-961. This complaint opened alleging that respondent failed to display its certification number on the advertisement notice sent to the public in violation of Tennessee Code annotated 6232-316D. The complaint included the advertisement allegedly missing the company's certification number. Upon inspection, the advertisement does not include the certification number. In this case, I recommended issuing a letter of warning to the respondent and closing the case.
First offense.
Madam Chairman, I make a motion we concur with the recommendation of council.
This is their first offense in any way? Okay, we have a motion by Mr. Roberts to concur with council. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Case number 15 actually involves 4 complaints. 2 have been presented to the board previously, and 2 are new complaints. They are case numbers 2014-031-851, 2015-010-291, 2015-021-4101, and 2015-021-4011. These complaints opened alleging that respondent company and qualifying agent failed to submit registration of employees within 30 days, as well as failed to submit termination notices timely, both in violation of Tennessee Comprehensive Rules and Regulations 0090-01-.06, subpart 9. As I stated, the board previously assessed civil penalties and issued proposed consent orders on 2 of the aforementioned complaints, being 2014-031-851 and 2015-010-291. The civil penalty amounts for those 2 cases totaled $26,600. The allegation for 2015-021-4101 is a failure to submit termination notices for 6 employees, and then the allegation for complaint 2015-021-4011 is that respondent failed to submit registration for 8 alarm employees. In anticipation of the complaints being presented to the board for discussion, the respondent did request an informal conference for discussion regarding the open complaints and the proposed consent orders. Respondent stated that a former designated qualifying agent discovered the oversight of a prior DQA, so there are 2 DQAs, and he submitted the registration applications and termination notices to the board office. Respondent states that the company policy has been to have all employees registered with the Alarm Systems Contractors Board out of an abundance of caution. Respondent states that the company has taken corrective action internally to prevent any additional oversight as it relates to registration and or termination. Respondent apologizes and states there was not an intention to violate any statutes or regulations, and upon discovery made immediate efforts to correct the errors. Respondent asked the board for leniency in assessing the violation regarding these administrative tasks. Using the number of employees listed in the outstanding complaints and the civil penalties assessed in the proposed consent orders, a total of $46,900 will be a standard recommendation. That information was relayed to the respondent, and he offered to submit a $30,000 payment as a settlement of the proposed violation. My recommendation was to have discussion by the board in regards to violation of Tennessee Comprehensive Rule and Regulation 0090-01-.06 and the respondent's proposed settlement amount. And if his settlement amount is accepted, the civil penalty will be allocated at $9,900 for 3 of the complaints, the failure to register the employees, and then the remaining $300 will be allocated to the complaint for failure to submit the termination notices. I'm sure that was a lot of information, so I'll try to answer any questions
Wait a
you all
minute.
have.
Your math's not adding up.
I don't grasp the arithmetic there.
9,900 for, there's 4 complaints.
I know, but he has agreed to a settlement of 30,000, and we've come up with 10,000 and something. You know,
No, it's
9,000 for each of the
Each
first three complaints.
first
I'm
three
sorry.
complaints.
So 9,900 for complaints,
Okay.
201403.
so you times the
Yep,
9,900 times
for each one of
3.
those respectively.
Okay.
Okay.
Madam Chairman, I make a motion that we accept the $30,000 as a settlement as indicated and be allocated as recommended by our council.
Okay. We have a motion by Mr. Roberts. Do we have a second?
I'd second. I think if they're making an offer to settlement, we should move forward with that.
Okay, and a second by Mr. Cockcroft to accept this settlement proposal. All in favor, voice. Go ahead. Go ahead.
I was making sure I'm recusing myself from this particular case and not voting.
He's reclusing.
Oh,
himself.
okay, okay. All right. We have a motion by Mr. Roberts, a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? And let the record show that Mr. Harvey did not vote.
Let me add a comment to this, and I think this goes back to what I consider a long-standing policy of the board, while not officially stated, but basically I feel like what the board is trying to do is to bring people into compliance with the statute, and I feel like that's probably more important than the actual monetary amount, and I feel like that this settlement moves in that direction, so I think it's an appropriate action. Thank you.
I do have a few cases for the board to represent to the board. The first is 2015-019-191. This was the consumer complaint alleging misconduct by respondent. The complainant stated that respondent came to his home indicating that his contract was acquired, and subsequently the complainant entered a new contract. The complainant states that after contacting his original alarm company, he learned that respondent misrepresented the acquisition of the contract, causing him to enter into a new contract. Complainant states that respondent initially refused to cancel his contract. Initially, we thought that the respondent did not offer a response to the instant complaint, but the complainant did confirm that the contract was canceled and the equipment was removed from his home, and the complainant was satisfied with that corrective action. At the prior board meeting, the board authorized a formal and sending a consent order with a civil penalty in the amount of $100 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.07, and a civil penalty in the amount of $250 in violation of Tennessee Code Annotated 6232-320C. By way of update, subsequent to issuing the consent order, respondent indicated that a response was in fact submitted to the instant complaint on August 19, 2015, following the respondent's receipt of the complaint from the Consumer Affairs Division. In the response, respondent states that the representative that sold the alarm system to complainant was an employee of an authorized dealer. Respondent forwarded the complaint to the authorized dealer to address any necessary corrective action and/or disciplinary action. Respondent states that complainant completed a pre-installation telephonic survey wherein he indicated that he did not have a security system and understood that respondent was not affiliated with any other company. Respondent confirmed the complainant's statement that the agreement was canceled, money was refunded, and the equipment was removed from complainant's home. My revised recommendation is to remove the $100 civil penalty as it relates to the failure to respond to Tennessee Comprehensive Rules and Regulations 0090-01-.07, as that response was timely received by a different division. And then further, for the board to discuss the prior finding of the violation of Tennessee Code Annotated 6232-320C in light of respondent's response to the complaint.
Okay, if he didn't have an alarm system to begin with, how could they say his contract was acquired?
He did have an alarm system to begin with. The respondent is saying they never told him that. They said they were not affiliated with any other company, and during his survey, he indicated he did not have an alarm system. So they're denying the allegation that they told him that.
See, it says respondent states that complainant completed a pre-installation survey in which he indicated he did not have a security system.
Right, and that's their denying, because the complainant said that he was told that they acquired it. So it's a
Okay.
dispute on whether or not that happened.
So which is it? You're, remove the $100 civil penalty?
I did my revised recommendations to remove the $100 for failure to respond that we assessed at the last board meeting, but I left it for discussion if you wanted to leave the $250 or if you wanted to change it based on that response. I wanted to give you the respondent's response for you to consider.
Okay. I don't see dropping that $250.
Madam Chairman, I make a motion we concur with the recommendation of council, remove the $100 penalty for failure to respond, and leave the remaining $250 civil penalty in place.
Okay, we have a motion by Mr. Roberts. Do we have a second?
Second.
Second by Mr. Cockcroft to concur with our council's recommendation, remove the $100 civil penalty for failure to respond, but to leave the $250 civil penalty in place. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The second case we represent is 2015-017931. This complaint opened alleging misrepresentation and unethical and unprofessional conduct by a respondent. Complainant alleged that a representative from respondent company came to his home and indicated he was there for a scheduled upgrade to his security system. Complainant states the representative's documentation and uniform did not have the same company listed. Complainant states that he indicated to the representative that as an alarm registered employee, he was aware that the representative was not presenting truthful information. Complainant states he would not allow the representative to perform the service, but rather contacted the local police department to report the representative's misrepresentation. Respondent did not offer a response to the complaint initially, but the respondent was a licensed contractor. I think that was at issue at the first presentation. And the board's decision was to authorize a formal and send a consent order with a civil penalty in the amount of $100 for violation of Tennessee Comprehensive Rules and Regulations 0090-01-.07 and a civil penalty in the amount of $250 for violation of Tennessee Code Annotated 6232-320C. The update is that respondent did submit a response to the instant complaint after receiving the proposed consent order. Respondent apologized for the complainant's interaction with the sales representative. Respondent stated that representatives should identify themselves by name and company, wear a shirt provided by respondent company, and provide work identification badge for inspection at the door. Respondent states that the sales representative was dismissed and deleted from their system on June 29, 2015. I brought this case back to the board for discussion regarding the prior finding of the violation for failure to respond and the misrepresentation.
Yeah, but they didn't respond until after they...
Right.
Did we get a termination notice on the employee in question?
Not in relation to this. I'm not sure if the board office received it or not. I don't know. We'd have to know who the employee was. I'd have to look.
I can look it up.
Be good to find out.
Yeah, I think I would like to know as well if they did submit the termination notice on this person.
I'm not inclined to change the original, though. I mean, they don't get a pass for responding to the fact that they didn't respond.
Deeper trouble, yeah.
Settlement order.
Hey, we can put that one on hold and move
Okay,
forward, and
that's all
after
right.
the break, give us a few minutes and we'll try to get that information back to you.
Well,
That we made a motion.
the case it's presented, no, we don't have a motion, I don't recall.
No.
That was my question as to the termination of the employee in question would be really, I guess, in the form of a separate complaint, if one seemed to be warranted. As far as this particular issue is concerned, I don't feel that any change in the board's previous decision is appropriate. Not wishing to make a motion in the negative. I think we just leave it as it is. It would be contrary to Robert's Rules of Order to make a negative motion stating that we don't change what we've already done. If we just don't do anything, then the previous actions would stand. Yeah. Move on.
If they didn't turn in a termination notice, what I'm hearing is they want us to set up a second complaint.
That is correct.
That's
That
kinda
we're not going to take any action on the previous civil penalty that was assessed.
The next represent is 2015-016-441. This complaint opened alleging that respondent was engaging in the business as an alarm systems contractor without proper certification. The complainant states that a representative from respondent company went to his home attempting to sell a home security system, and after investigation, complainant alleged that respondent was not licensed to operate in the state of Tennessee. Respondent states that the named company was a dealer of the properly licensed alarm systems contractor. Respondent states that it only billed the customers for the licensed company's monitoring service after they co-branded in April of 2015. Respondent does have a application pending with the board office. The prior recommendation, or the prior decision, was to authorize a formal and send a consent order with a civil penalty in the amount of $500 and waiving the 6-month application waiting period after the civil penalty was authorized. Their counsel contacted me, and by way of update, the respondent states that on March 31st, 2015, a letter was mailed to the board office in anticipation of questions regarding that co-branding and offered an explanation for each company's function. Respondent states that hearing nothing from the board office following the March 15th disclosure of the co-branding, responding company went forward with the co-branding. Respondent reiterates that the named company simply bills each customer, with the licensed company performing the installation and servicing of the alarm systems. Respondent states that it has submitted an application for licensure and had no intention of violating any laws or deceiving the board in any way. Respondent requests that the potential violation be dismissed, and if there is a violation found in the future, the fine amount be increased above that imposed during the normal course of business. In the alternative, respondent requests that the violation be stayed, and if there is a future violation, that those violations in the subsequent discipline be increased. Respondent states that it is committed to following the licensing laws and is willing to appear before the board for further discussion. I brought this back to the board for discussion regarding the prior finding of the violation of Tennessee Code annotated 6234-304E in light of the new circumstances.
They have applied, they are in the process. I'm here again, I'm not inclined to change what we did before. I think we were reasonable. We allowed them we waived the 6-month application.
And their attorney, he did offer a couple of times to appear before the board, but because this is an open complaint, I told him that is not the stage we're at yet. But he did want me to stress that they did ask for permission to do this co-branding in March before this happened in April. He wanted me to stress that they sent a letter to the board office. They heard nothing, and so they moved forward. So they wanted to show that there was no intent to violate the laws by what they were doing, and ask that you all reconsider that information.
That's one of the things that's very clear, though. There is no co-branding. There's no. That is a violation, and that should be pretty clear to a qualifying agent that they can't do that.
Joint venture.
Right. It's a.
And the board office stance is that we have not found that letter.
When I asked the attorney how it was delivered, if it was by email, by fax, he said it was that, I guess that employee said they sent it first class mail addressed to the board office, but he did not have a particular name, he did not have a particular date. He didn't send it certified mail, but he said he sent it just first class mail.
However, when you spoke with him, and he told you that he sent a letter in March before they started this joint venture in April, I'm sure somebody told him that joint venture.
Well, and he did not say joint venture, he said co-branding. So that conversation was never had.
I didn't know what co-branding was. I'd say, what is that? Then I would say, isn't that joint venture?
I was going to say, I'm not real clear on what the term co-branding refers to in this particular case.
And I think, and I want to preface this by saying I don't want to speak on behalf of the company. I can just go by my conversation with their attorney. I think they're believing that because they separated the activities of the parties, so this one company was simply billing the customers, even though the name was on the shirt or whatever, that wasn't necessarily the joint venture. So co-branding in the sense that they're billing, they're servicing. Billing is not something that is required for licensure, but by way of moving forward with their company, they do have an application on file now, as we knew at the last board meeting. But like I said, I brought this because I had been speaking with counsel, and he wanted the board to reconsider that information and stressed that he would be willing to appear before the board on this matter if need be, prior to going to hearing if
So
it gets there.
when did this original, when did they go to the door? Went to the, in the first paragraph, when did that incident take place?
I'd have to look back at the complaint file.
They're not disputing that this person wasn't licensed
They're not
to
disputing
do
that the person was there with this unlicensed company's name on there. They're not disputing that. They're saying that it all happened after they asked the board office for permission and got no response.
So the only other thing I was thinking of and mentioned is if we need
Madam Chairman, I would make the observation that their attorney involvement probably has already cost them far more than the $500 proposed civil penalty. And if they don't understand that, then they're
And their
not,
attorney
not very astute.
and their attorney is out of state, and I did inform him that we could possibly do an informal, but he wanted me to present this to you all first, but make the same assertions that I've made a couple times now. So
I really think it's a reasonable offer. I mean, what the civil penalty we offered, because we didn't get into how many employees there were and other. I mean, that fine could be much larger if we got into how many aren't licensed for the company that they're doing co-branding with. It's a major venture to move forward with no response even. Why not send a second letter if you don't get a response? Before moving forward, a no response wouldn't be good to move forward with a business that you thought might need to be licensed. I don't think we should. I think we should leave it as is, and if they want to move to a formal hearing or do something else, they could.
That's a general consensus. Y'all have any desire to
I agree
change?
completely with Scott.
We're gonna let it stand.
Term, it's easier to ask for forgiveness than permission.
Okay, next one, please.
and the last we present is 2015-01791 and 2015-01792. This complaint did allege that respondent failed to display its company certification number on the company truck in violation Tennessee Code annotated 6232-316D. The complaint included photographic evidence of the respondent's company vehicle, and the evidence submitted did not include certification number on the vehicle. The complaint also stated that the respondent's website failed to display that certification number. In response to the complaint, the respondent did admit that the certification number was missing from the company vehicle. The respondent stated that the violation had been corrected on the company trucks, and as of the date of the last board meeting, I believe that was September. Is that correct?
December.
December, I'm sorry.
It's okay.
December, they had failed to display that information on the website, and the prior recommendation was to issue a letter of warning and close. The board agreed with that, but they did want to leave the case open to see if the website had been updated. And we did check, my paralegal and I, and the respondent did in fact update that. So I want to give the board that information that the website was updated to include those certification numbers. So the revised recommendation is just to close the case at this point.
Okay.
Madam Chairman, I make a motion we concur with the recommendation of council and close this case being satisfactorily resolved.
Second.
Motion by Mr. Roberts and a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye. Aye. All opposed? The motion carries. Thank you. We're going to call our meeting back to order. According to the agenda, I think we have,
I want to go back, Madam Chair. We have the information that you asked for. If that was a complaint that you wanted us to look up.
about the employee.
Right. They didn't need to terminate him. His application was denied based on a material misstatement.
You had to tell which one it is. Which complaint was it and the number?
2015-017931.
Okay.
And the employee application was denied based on a material misstatement on June 24th, 2015. The complaint was actually filed on June 24th, 2015, and the letter from the company said that he was terminated on June 29th, 2015, which is about when they would have gotten our denial notice. So,
So they're in sync with the law then?
They had applied and he was.
He did apply.
Okay.
Okay. Then,
That was more just about whether we wanted to open another complaint.
I was just curious, sometimes you find companies that will
do things not quite by the law.
do things inappropriately or not do things appropriately.
Okay, now that we've got that matter resolved, I think the only thing left is F.
All right, that is alarm employee application review. If you would, we got several of these, 13 if I'm not mistaken, so if you would turn to F1.
Are we going to say these people's names
I
this
don't-
year? Okay, good. We have to refer to them by their
F1.
file number.
Uh-huh. If you would look there. This individual did list a 2008 and 2010 theft of service, theft of property, the $500 or less. Does have a written explanation in there as well. And you do have a letter from the police department also. Memphis Police Department.
Did he provide any explanation about the nature of the theft charges?
Have everything
You've
we've gotten, and I had to beg for this.
I was wondering the same thing. It's like, I don't see that addressed there at all.
Well, it looks to me on the theft, it had, and no, you have everything we have from him. 16.
What you're seeing right there is the 2008 guilty, and the 2010, it is still in process. It has not been.
Oh,
That's what the letter is from the police department.
There's still no disposition from this case. I know the detective.
only have part of the application here. What is he applying for?
These are all employees.
Employee registration.
Technician helper.
I think based on the limited amount of explanation that we got, that perhaps an appearance before the board would be in order.
Okay, Madam Chair, are you asking if we can bring the individual in to
Well, I mean, that was just
speak
be,
before the board?
I think that would be,
Yeah, just get them.
yeah, we just need a.
We don't have anything from his QA either.
Sir, we don't ask for that anymore. Well, I mean, we do, we try, but we, since we have a company that says, I'm not gonna give it to you, never give it to you. Now I can, if one company doesn't wanna give it to me, and we do ask, and then if you don't, we just don't pursue the matter.
Well, if you ask and they don't give it, then they didn't give it.
Right,
But
we just don't pursue the
I
matter.
mean, the application is very clear in what they're supposed to submit with it as far as the records, and in the case of a criminal conviction, a letter from the qualifying.
I don't see here submitted enough information for me to make what I would feel like a reasonable decision in this matter. So maybe the inviting him and perhaps his QA to appear before the board would. I so move.
Does it matter much whether it's denied at this point, or we do ask? In fact, him having, if we deny it, he has to reapply.
He has to reapply if you deny him.
Well, if
This
he-
one
if the
here's gonna
board-
stay open.
If the board denies him, he has to appeal it and appear before you anyway, so.
So
But he
it is
wouldn't be
helpful
able to
then for us
work.
to, just to request him. And of course, they can decide not to, or not further that, okay. I'll second that motion.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to request this applicant F1 to make an appearance before the board with his QA. All in favor, voice by saying aye. Aye. All opposed? The motion carries.
All right, thank you. We'll go to F2. Should have a list right there of the offenses. Oh. April 2010, this one is still under judicial diversion. July 14th, 2010 was the guilty, and that's why
So we don't know what happened to the 4 or 5 case or charges that were bound over to the grand jury last summer. Got the Williamson County.
Yes, I show the Williamson County for the guilty, I mean.
Notification of an accident, leaving the scene, implied consent, DUI.
On the 4, 5, or 14.
What?
His explanation, wasn't it?
Yeah, his explanation's here. Looked like he pled guilty.
Failure to report an accident.
And it was dropped down from DUI.
Yeah, it looks like the DUI, according to him, the DUI was dropped, resulting in a guilty plea of reckless driving.
I know, but I'm just not seeing it in the criminal
Oh, okay.
record. I saw what he said, but I wasn't finding it in the.
That's just what's typed up here.
What's
I
that?
typed on the,
Subtracted it.
I typed the front page up. His disclosure page is in there. He might, if it said see
Do you have that
attached,
one?
I didn't put it in there.
It's,
We get a lot of them that just say see attached. Yeah, his said see attached, so all I included was the attachments.
that's
There
his
wasn't anything.
explanation, but,
So you need to stay home and drink.
well, he did, and he got caught with.
This came with the application. That's his.
I believe so.
That's the one that he said.
Well, no, they're all showing up Williamson County.
Yeah, he says that, I think the public drunk, it shows it was dismissed. But those others, it just says bound over to grand jury, but there's no final disposition in here.
And then we were going by what he had on, we were going by what he had on his written explanation. Would you like to see this gentleman to come in and bring in his QA? If there's not enough, I don't know where he's from.
Madam Chairman, I think it'd be a good idea to let this gentleman appear and sort of explain some of these circumstances that we see here. I suspect it's a little bit marginal, but still, I think we're entitled to a little bit more explanation in what we see here. He'd be coming in from Franklin, Williamson County. That shouldn't be an undue burden. I think I'd like to have this gentleman, I assume it's a gentleman, Ron, yeah. I think having Mr. Ezell appear before us would be a good idea. Oh, I'm sorry.
F2.
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 No names. Okay, we have a motion from Mr. Roberts to request F2 make an appearance before the board. Do we have a second?
A second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? Sure.
Normally, when we ask someone to appear, we ask their designated qualifying agent to come with them.
Oh, let's bring him with him, or her with him.
That's what I put in there.
All right, we can move on to F3. It's going to take you a few minutes to look this one over.
So F3 and F4 are two different individuals with the same last name? Okay.
are just so hard to read. Here's another guilty false report in our This one came before you because it looks like there are several guilty charges. One, 5 years probation for the 10/15/2012.
I asked our public member what a fourth degree assault was in Kentucky. Do you know?
In Kentucky, I don't know.
'Cause Tennessee
but
doesn't
fourth degree,
use-
it could be something that's just as something as verbal or grabbing your arm. I mean, it's
Minor injury.
there, yeah, minor.
Minor injury citation is, if you look on the first court record, charge filed, assault fourth degree domestic violence, minor injury citation. That was in '09.
Make sure, pardon me, make sure if you're having a conversation, we do hear it on the tape.
I asked her what a
Finding-
forged instrument was.
Okay.
I was thinking forged as in blacksmith, make a shiv or whatever, you know. I didn't think about forgery.
It's usually either a check that you sign somebody else's name to, or,
But the instrument,
yeah.
after forged, I thought device.
Well, if you don't work with these every day. it makes
Never made a
difference.
shiv yet.
There's not any statement on behalf of the applicant here?
All I did was send in the court record, so that left us in a position of not being able to close the file for not providing documents.
I know him, I don't know him, but. Got the letter from the DQA, but we didn't get the explanations from Farmer.
On a letterhead, so would have been better to be on there, but.
The charge on 7713 says serving warrant for other police agency. Is there any explanation of this?
Yeah, it would be, there's a warrant for you in Hamilton County, so your county comes.
The record returns
Oh, there's a hit
that
on
we
him, so they
get
serve a
now
warrant.
don't even show the city and sometimes the county. It'll just list the state and then say Metro Police Department, Kentucky. So
So that's not really a charge.
No, that was just an action in the case. But I've noticed in your, yeah, because there's a lot of, he's moved and all of the documents and things come back for insufficient address or no forwarding address, and he's also got a lot of failure to appears. He's on probation for something until 2018. Is that what it was?
Whatever
Yeah.
it was. It could have been a prescription, I guess. I mean,
I don't know what cold checks are either. That's a new term I'm not familiar with.
isn't that when you've closed your account and you keep writing on them?
Could be.
I believe it is.
Well, we could ask this gentleman to come in too.
That'll be all right with me, but
We
I'm
need to
not
know what all
even
this stuff
sure
means.
that I'd even do that after that.
I'm just looking here at this list of stuff, and I'm really not. I keep asking myself the question: Is this a guy that I would not want installing an alarm system in my home? And even though he's got a bunch of charges that they really, in my mind, would not particularly disqualify him from installing an alarm system. I suspect that if we had him come in, that the answers we would get would not change that decision much either. So I make a motion we go ahead and grant this application. It's kind of a convoluted situation, but again, I don't see anything here, and upon the recommendation of his qualified agent, I don't see anything here that would, in my mind, disqualify him from installing alarm systems. So I make a motion we grant the application.
Okay, we have a motion by Mr. Roberts to grant this employee registration. Do we have a second? Appears that the motion has died for lack of a second. Is the way the format that this gentleman has written that letter, is he writing that? I thought he was writing it like as a individual, but he lists in there that he's the boss, but yet he puts his company at the end of it in the bottom line, but there's no certification, no nothing. Is that something that's...
A letterhead.
Really on letterhead, it's just like a personal letter.
But he puts he says
I
he's
know,
the
he put the
boss,
company
and then he
name
put
down there. So, there's no company, I mean, have you fined people for not having it in their emails before?
Yeah.
And they have a tagline on there which usually has their company logo. It's really up to you guys if you feel like.
He responding as the qualifying agent, and I don't know that it's.
He sent this in with his application. This came in at the same time it came in with everything that we got. And why he would do that and not send any explanations,
I don't feel comfortable with granting it.
probation, they always have, they can appeal it and then ask to appear.
Oh, it died it failed.
If we were to deny it, would be based on poor moral character. Make a motion then to deny F3 based on poor moral character.
Okay, we have a motion by Mr. Cockcroft to deny based on poor moral character. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed? No.
One nay, Mr. Roberts.
Right, we can move on then, thank you, to number 4.
F4.
F4, which is very easy. It's just 2 pieces of paper. It was a petty theft in 2013. Probation completed January 13th of 14. Guilty.
I have emailed the compliance agent for the central station where this lady works and asked for her explanation 3 times and still don't have it, so.
On the record here, I mean, she's saying, or the person, I don't know who the,
Yeah, number 4.
is, like, there's. On the application page, where,
Oh, okay.
did the court dismiss the charges against you? Yes.
Expunged.
I don't see that anything in this paperwork that shows they were dismissed.
Simply be another. Ever appeared for the court? Yes. Did they find you guilty? Yes. Were we placed on probation? No, but here's the paperwork that says yes.
Well, it shows she was guilty on the findings on that, on page
List
2.
of charges, she said yes. Then she comes down here, or this individual, whereas the expunged, we hit the wrong little category. So, all that was provided was the court document. And it shows no contest, guilty.
What would petty theft be? I
Bound to get-
mean, what, is
That's
that
gonna, it's,
under?
most of the time it's
Uplifting, it
under
could be.
500.
Yeah, I knew that one.
Probably shoplifting.
Fine, 200.
Awful recent and without an explanation.
Madam Chairman, I make a motion we go ahead and grant this application.
We have a motion by Mr. Roberts to grant this employee registration. Do we have a second? Second. And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed.
Right, thank you. We'll go to F5. The last thing in your packet is a letter from the company.
For monitoring?
No, he's a sales rep.
Praise, didn't we?
He comes in here from somewhere and goes knocking door to door or installs. If he's a sales rep, I'm assuming he's going door to door.
He has a typed up explanation or a list of charges anyway. One we really like for you to look at is that 2013 assault that is still open. So he hadn't been convicted. Disturbing the peace, guilty. What kind of candy is it?
Since AMP's Tennessee license number is not on their letterhead, would it be appropriate to assume that it was on some other documentation?
Well, it's in the middle of the
body of the letter.
document.
Okay, good.
Let's put it somewhere different. Qualifying
Yeah, I
agent's
see it.
number and
Thank you.
company.
Look for it.
Is the very last thing in the record?
Letter from the QA.
Well, on the, no, on the,
It's the
on,
assault charge that has
well,
not
there's like,
come
it
to-
says written plea of guilty at 3/23/2015.
That's what I was wondering, what that, if what
Is
that,
that for the last charge that's, I don't remember what the date was on the last
There was a
13.
contempt of court or something right after that, but some kind of contempt of court, but the Indianapolis charge from 2013 is the one he says he on his FBI report. It lists the charge and it said no disposition information is on file. And it looks like this was run in June of 2015.
All the rest of his stuff was in Idaho. He must have went to the Indianapolis 500. Got in trouble.
okay. Any more questions? Favor on this? I just have concern he's got an open sexual assault charge on him.
They usually wait till they clear it, don't they?
Matter you can deny it and tell him to reapply when he gets it resolved.
Charges are going.
It's up to you guys.
I make a motion that we deny it for now until the charges are dismissed or settled. And he can reapply, and we'll deal with it then.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Roberts to deny the application at the current time due to a pending open criminal complaint, and then he can reapply when that's all resolved. All in favor, voice by saying aye.
Aye.
Aye. All opposed? This application's denied.
All right, thank you.
I got a real quick question, and I might need your help, Ashley. It won't be under the poor moral character clause, or would it? Because he's still got pending charges?
All about charges pending.
I can make the letter say due to open criminal charges, and he's eligible to reapply once they're resolved.
All right, we can move on to Exhibit F6, if you would, please.
I have two F6s with
Me too.
an H
Two
and a
different
K.
names.
Got
So
two
s-
F6s?
Yeah,
Yeah.
so
One starts with H and one starts with K.
I think it's probably supposed to be the 7 or something. on the
Probably,
second
I
one.
didn't-
K is 7. So the one with the H is a 6.
Go to F6H,
Yes.
subparagraph H.
It's just in the,
Oh, when I named them?
yeah, when you named it.
Got part of it right. All right, petty theft.
We don't have any sort of explanation from the individual or from the QA.
So all they do is just send the application in, send money, and these court documents.
Make a motion we deny this application.
Second.
We have a motion by
Under
Mr.
grounds.
Roberts,
For moral character.
Okay, I just needed it in the record.
And a second by Mr. Harvey to
I got
deny
that.
F6 beginning with the H. All in favor, voice by saying aye.
Aye.
All opposed? Denied.
Right now, we're going to go to what I show as Exhibit F7.
I just named them wrong. Sorry, guys.
One that starts with a K.
Seven, eight.
No, you got
They're
two
both
sixes.
F6s.
Two sevens.
I know, I just,
K6.
when I named the document, I used the wrong letter, number.
Says F7 on the,
Oh, yeah, once you open it, it says
It's
F7.
the,
Yeah,
the
I-
title
you
of the
know.
documents, just, of the files, just wrong.
Well, you
It
know,
should
when
be-
you scan about 30 files to yourself and then you have to open them and save them as a whatever, if I only made one mistake, I think I'm
You're
doing
doing pretty good, aren't you? Yeah.
He only disclosed the most recent charge he has, which was pretty serious all by itself. He didn't disclose anything else.
Still on probation too for a drug charge.
guy out walking around, or
He's working for a company,
working.
yeah, that, well, they're
Driver's
in
license.
Fort Oglethorpe, Georgia. He's a technician. On probation, and he didn't tell the truth, but due to the charge, instead of denying him MM, I'm like, well, look at it.
You need to look at the last sheet. That's the sheet from the counseling service where he's apparently in treatment or had been in treatment, and he will be finished on June 15th, 2016.
2015.
16, it says on my
Scheduled
paper.
completion date is 2016.
He's been
Oh,
yeah,
since
he-
2015. I'm sorry.
Means he's in their residence program, and he's on work release or whatever they.
Behind the actually behind the application, the one that's from Georgia tells you what he was charged with and what his sentencing is.
The application until after June of 2016 till we find out if the course is completed.
Basically, just denied, don't you?
And
And the
Really?
poor moral
just
character.
denied. Yeah.
Well,
Well, he's on
Yeah.
active probation through 2020, plus he's got several other convictions involving drugs and so forth.
Second for discussion.
Go ahead.
I'd like to amend that motion just to deny all the.
That's what we would be doing. There's really no. It's
No,
just-
no.
yeah, because I was
denied
going
her.
to say reapply after 2016, but that's the same thing.
So the amendment is now, the motion is to deny completely and seconded by Mr. Harvey. All in
Because of
favor?
outstanding charges.
Okay. So deny F7.
All right, we ought to be on track with F8. Oh, did you vote yet?
Yeah, now we're getting ready to vote.
Probably won't vote on that.
Oh, that'd be really nice. I
Okay.
appreciate that. Thank
All in
you.
favor, voice by saying aye. Aye. All opposed? Now then, go ahead and Ms.
Now,
Take it away.
We can move forward with
Yes, we
F8.
can.
We did 6.5, then we did it.
This one here is a reply. This individual here is a reapply made application on July the 28th, 2015. We denied for material misstatement.
would it mean where they've put terminated under the
Sentence.
sentence?
Probably like they finished the conditions of the court.
That's what it says on the court record. It says 8/2/2005 terminated. But
Back here on disposition, it says dismissed after completion of diversion.
which one's that?
The next page after the second page.
Not the assault. Assault says judgment of conviction and a suspended sentence.
Either pled guilty or was found guilty of the assault, simple assault. Voucher ordinance. She got a 30-day suspended sentence.
Hey.
She's not had any arrest now in 11 years.
Madam Chairman, I make a motion we grant the registration of applicant F8.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to approve employee application F8. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we can move right on to F9. This individual has a charge of a domestic assault, which will not complete diversion until 2016. We have a written explanation. Yeah.
They all use generic letterhead. Usually the
Madam Chairman, I make a motion that we grant this registration.
Okay, we have a motion by Mr. Roberts to grant this employee registration application. Do we have a second?
Second.
And a second by Ms. Jones. All in favor, voice by saying aye. Aye. All opposed? The motion carries. I think it was brought to my attention, Mr. Jackson's not in compliance on his paperwork.
Actual,
Have a C number on the correspondence.
is it actually a hard copy? Don't they print them on the back sometimes, or the?
So, I mean, again,
On the back.
I want to think this.
Doesn't matter. We gotta be able to see it.
If we received
Oh, this
it
is
as-
the original right here.
Okay.
There's nothing.
We kind of thought maybe it was up there in those four names, the name of the company up in that black.
Okay, we're ready for number
I'm story in there,
10.
Scott.
But
I'm story.
I really thought at one point they printed like a whole list of numbers on the back, but that may not be
ADT does
acceptable
that. I don't
anyway.
think Tyco has. ADT has done that and put them all at the very bottom for all their different states and the 6 they have in Tennessee.
Letter 1.
Fire part and alarm part.
Yeah, since they separated, I haven't seen that type of stuff come from.
I didn't know they
someplace.
separated. That's what he was telling me.
Okay, we'll take a look at that and set up the necessary complaint. If you'd like, we can go now to F10. Going to take you a little while to read that.
Yes.
Yeah, and taped them on. Look, there.
Oh, okay.
He took no. Taped them on, and here's. I mean, you gotta really. At least he
Like I'm
did
supposed to.
something.
I at least can stay away from hard candy.
Am I supposed to?
I knew you would.
Board had an opportunity to review case F10, and if so, a motion to approve or deny.
He's a technician, so that's what he does.
Simple possession. Domestic assault. Protection. That's kind of sums it up, doesn't it? His statement was that he got in an argument with his
Oh,
girlfriend.
is that the one he put down on the ground?
Yeah. Thing recent is the violation of order protection.
And it was dropped.
The only thing in his favor on that one is that he did actually he basically turned himself in, is what happened on that, right?
Yeah, that's what he indicated.
He said he didn't know there was an order of protection.
That's very possible.
Now he says the order's been dropped, and it was time served, the 12 hours, and it was over.
I guess this isn't working.
Madam Chairman, I make a motion we grant this application.
I'll second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to grant F10's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed?
Okay, let the record show that Mr. Cockcroft.
F11.
I did ask for letters from the, I got his explanations, but I didn't get anything from the Q.
Move past the application and move on to his explanation here. Indicted and pled guilty. Conspiracy to distribute meth. 51 months.
And then to 41.
Then to 41 months.
Year that he was in the program and got
Hey, what charge? Exactly.
when he completed the drug program because he had 41 months. That's just a little over 3 years. And the last charge was 2013.
Indicted in 2012.
Right. He started his sentence.
Our date's in
I'm off.
November.
I'm all for giving people second chances, but I just think there's some,
That's his third.
yeah, sometimes there's just time that passes, but this is not an industry for everybody.
He had simple possession in 06 and then meth.
Had it in '01 and didn't disclose it. It wasn't a conviction, but he didn't put it on his application.
I mean, a second chance at life. I don't mean, I
Yeah.
mean, he, you know, as far as he.
Somebody that's not trying to straighten up wouldn't have used some of the words he used, BMI and stuff.
Federal prison.
Yeah.
He took the program.
Yeah.
Is that when he was in federal prison?
Yeah,
He
I
took
was
the
just
program.
wondering, you know, when he completed that.
Madam Chairman, first of all, I'd like to state that even though this individual is apparently from McMinnville, Tennessee, I have no knowledge of this individual nor any of the circumstances surrounding it. But based on what I see here, I would not be comfortable with granting this registration, and so I make a motion we deny his application.
Second.
Okay, we have a motion by Mr. Roberts and second by Mr. Cockcroft to deny this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries to deny.
Move now to Exhibit F12. And then also we'll take you a little while to review.
This is one I'm probably glad you didn't print out.
There one, I didn't.
44 documents.
Left in 2012. Material misstatement in August and then turned around and reapplied. That is not copied in there. I apologize. Sales rep who goes door to door, if that makes any difference. I'm just glad she's off my desk.
Glad your desk withstood the weight of the paperwork involved in that particular situation.
So now you're a novelist.
I feel like it.
Body of it.
His name sounded familiar.
They probably should know that they need to put it on there.
They've probably been fined
Okay.
at some point.
Do we have a motion regarding this application? F12 is the file number.
Other opinions up here.
It seems like a lot of excuses. I'm inclined to deny.
I agree, because I found it was always,
Seems like it's always somebody else's fault.
On the grounds of poor moral character? Or you're thinking about it?
was that going to be your motion?
I'll make a motion to deny based on poor moral character.
We have a motion by Mr. Cockcroft. Do we have a second?
A second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? It's denied.
All right, let's go and skip right to the very last one.
Number 13.
That'd be no
I was looking
F13.
for one more to add, but it was 4:30.
Thousand and six, guilty of possession that, was off probation in 2007.
Make a motion to accept F-13's employee registration.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to approve this employee registration application. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
I believe that does end my section here, Madam Chair.
That ends yours. Okay, have we got anything else collectively that we need to discuss? Okay.
Yeah, but we do have a new business. What we would like to do, staff and I have been looking, and we would like to ask you if you would let us make the determination to
Grant the second
grant the
90-day
second
extension
90-day
to
extension
replace your DQA.
instead of bringing. You already granted us the right to do that for the first one. We're asking for the right to do that for the second one.
Problem with it?
Third one. Yeah, because they,
290. 90 days. All right.
apparently we're having some companies are having difficulties finding some qualifying agents.
They can
And
pass
they're
a drug
trying-
test.
Yeah, and they're trying, the ones we have in our office anyway, they're trying to become their own DQA for whatever reason. They need the time.
I don't have a problem with that. I was just trying to think through when a case would be when y'all are still making judgments on, it gives you the ability to grant it, but you might.
Bring it before you if there's anything that was out of the ordinary, yes.
On the up and up, but I happen to know of one that really is trying, but yet they're still having a hard time.
Okay, do you want a motion to allow it?
That way it'd be on the record and we can do that.
Okay.
If you so
I make a
choose.
motion, we allow our staff that we give them the authority to grant a second 90-day extension on applications or
Do you fill vacancies under the QA?
okay.
As a qualifying agent.
To give a second 90-day extension for, to find a QA, they can do that administratively.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to authorize the staff to grant second 90-day extensions to companies seeking a QA. All in favor, voice by saying aye.
Aye.
All opposed? Okay,
Oh, we have, Madam Chair.
all right, no unfinished and no more new business. This meeting is adjourned and we'll see you in April.